In the name of Almighty Allah, who is most beneficent and merciful to us. In this talk, I would like to discuss the judgment of the Honorable Supreme Court of Pakistan as reported in PLD 2019, Supreme Court 749. Although some petitions were clubbed together, but for the purpose of this discussion, the main title referred in this judgment is that of Muinuddin versus the state. The background of this judgment is that which is having the pivotal scenario, first of all, for deliberation and discussion, that at some stage when all the courtal formalities had already been exhausted by the appellant up to the review before the Honorable Supreme Court of Pakistan, in the normal course of legal system, criminal review in criminal cases is the last and final remedy. But in this matter, there were two offences against the appellant under Section 302 PPC, which is certainly compoundable in nature as postulated in Section 310(0) of the Pakistan Penal Code, read with Section 345 of the Criminal Procedure Code. But the other offence for which he was charged before the trial court and then was awarded death penalty, which was upheld by the Honorable High Court, then ultimately the appeal before the Honorable Supreme Court of Pakistan, and finally review was dismissed. Although along with this case titled Muinuddin, as many as 5 other cases were also referred. Those two were pending before the different benches of the Honorable Supreme Court of Pakistan, but those were having a different background and stages. But the main proposition in all the cases was that if a compromise has been effected between the parties, what is its effect on a coordinate offence which is a non-compoundable in nature, so like 396, wherein a murder has been committed during the attempt of dacoity, which is certainly a non-compoundable offence. And in the similar fashion, if the provision under Section 7 of the Anti-Terrorism Act has also been applied, likewise under Section 365A, wherein some accused has been convicted and sentenced and awarded death penalty in the cases of a ransom, deduction for the purpose of a ransom. So this was the scenario. Here, my focus is on that very altogether a different scenario in the case of Muinuddin. So the Honorable larger bench of the Supreme Court main objective was, despite the fact in the past some judgments have been rendered by the different benches of the Supreme Court of Pakistan in a similar scenario. However, for the purposes of guidance, this aspect of the matter. So firstly, let us draw a distinction between this case, the background of the case of Muinuddin, as well as other cases. And other cases mean yet that the case has not reached at that very stage of final culmination, as I have referred supra, the, the remedy of review has also been exhausted. So as far as the question of that reviews, it has been held by the Honorable Supreme Court, rather reiterated in the light of the earlier judgment, the view taken by the earlier benches of the Supreme Court of Pakistan, reported in different case law, many as even mentioned in this very judgment, 7 numbers. The reference of the provision available under Supreme Court rules and orders 1980, and that is relevant order is Order 26 Rule 9, wherein it has been specifically a bar has been created, that the embargo has been imposed, that no second review in form of criminal review is available to any convict and appellant, in spite of the fact that at subsequent stage, and that the capital punishment which was awarded by the trial court and upheld by the superior forums has not attained the finality. As we are all aware of the fact that during the regime of President Zardari, lasted from 2008 to 2013, there was a moratorium, because it was the decision of the executive that death penalty a moratorium was imposed, a restriction was, therefore time passed away and numerous convicts could not be hanged, rather that capital punishment was not executed. So when this distinction, I again revert back to this distinction, if such like situation arises wherein the matter is, if it is pending before the trial court and the compromise has been, the plea has been taken that the parties have compounded the offence, but at the time of passing of the final verdict, so after the recording of the evidence, an application can be filed under section 345. However, even at that stage, the court would not, even considering it a distinct and independent offence, if the offence under section 365A, 396 PPC, as well as under the provisions of Special Enactment of Anti-Terrorism Act. So this premium cannot be extended except a reduction of sentence. For example, if it is a fit case for awarding the death penalty, and despite the fact the compromise has been effected, in the compoundable offence, which is a coordinated offence under section 302, but at the most that would be reduced into in the similar situation. The cases are at the stage of revisional or appellate and matter is pending before the Honorable High Court. This aspect of the matter can be taken into considered on this principle while before the Honorable Supreme Court at the stage of leave to appeal, or appeal is being dealt with, as well as the review. And in the instant case which has been referred by the Honorable larger bench of this court, so if even the remedy of mercy petition has also been availed by the once, although it has been clarified in unequivocal and unambiguous terms that no second review as postulated under Rule 26, Order 26, Rule 9 of the Rules and Orders 1980, read with the relevant provisions contained in the Constitution of Islamic Republic of Pakistan under Article 187 and 188, that can not be entertained. However, if the mercy petition has also, then second mercy petition can be filed before the worthy President of the Islamic Republic of Pakistan under Article 45 of the that would be deemed a fresh mercy petition, and that would appellant and convict can avail that remedy through the jail superintendent by filing an application, and that too, if would be entertained by the only for the purpose of this is one everybody all concerned should keep in mind this significant aspect of the matter, except a reduction of sentence, considering it the aspect of the distinctiveness of that very offence being non-compoundable in nature, and through this judgment and with reference to the earlier judgment rendered by the Honorable different benches of the Honorable Supreme Court of Pakistan, available in different law journals, it has been discussed threadbare that the bar contained under section 345 subsection 7 of the Criminal Procedure Code is not vesting any power to the Supreme Court of Pakistan or any other court to convert any non-compoundable offence into compoundable on any score. So that is basically and primarily job of the legislature. If they want to bring any amendment in that provision of law, that procedural law, and for insertion, deletion, and we need even a new law that cannot be that power cannot be exercised. The most interesting feature, which while I going through this very judgment, some other aspects when this case was argued by the Learned Counsel for the appellant, some plea of taken that this scenario, yet when although up to the mercy petition and the earlier review petition of the convict has also been dismissed by the Honorable Supreme Court of Pakistan. So prayer was made to entertain this petition. It certainly came before the Honorable Supreme Court of Pakistan in a kind of second round of litigation by filing miscellaneous application before the trial court, then writ petition or under section 5(6)(a) or CRPC before the Honorable High Court, and then before the Supreme Court. But it is my understanding, certainly it is a past and closed transaction, and no review, second review is available to the convict. But the most for the learning purposes and for more for illuminating our minds and for guidance of all the person concerned with legal fraternity, judges of my level, the judges of the trial court, the judges of the Honorable High Court, some while referring some very significant case law, indeed the Learned Counsel for the appellant has exhaustively tried to convince the Honorable Supreme Court of Pakistan this larger than that the provision contained under Article 184, as you know, when the so moto powers are exercised by the Honorable Supreme Court, but that having a limited scope only in a matter pertaining to public interest litigation. Similarly, some advisory guidance contained under Article 186, 187, etc. Keeping in view this peculiar aspect of the matter, and another situation also taken into consideration by the Honorable Supreme Court of Pakistan with reference to some other case law particularly a principle of judgment per incurium. However, that scope has not been restricted and contained. If some error in the earlier judgment comes into the notice of the Honorable Supreme Court of Pakistan at its own, that particular error, it cannot be construed that that power can be abridged, that can yet be exercised. However, in the identical the matter case under discussion, since that can be reviewed, that can be revisited, but excluding this very matter, wherein it has been finally concluded that because it is deemed to be a distinct and independent offence, and no benefit can be extended to the accused and convict on the basis of the composition and compounding of the offence in the coordinate, as I have discussed supra. So, nowadays, because of in the wake of coronavirus pandemic, the courts are not functioning at its routine pace. So I have taken the advantage to discuss this aspect of the matter in a very precise manner. Yet, those appeal petitions have been pending before different benches of the Honorable Supreme Court of Pakistan. But for the purpose of the guidance of the trial court and the judges of all level, as provided under Article 189 and 190 of the Constitution of Pakistan, because the judgments of the Honorable Supreme Court are binding to all the executive and the subordinate judicial forum. For this very purpose, when I went through this judgment, I deemed it appropriate to share my views with respect to this. Thank you very much.